Welcome to episode 3 of Unreasonable Doubt, the Casey Anthony murder trial. I am Joel Oster.
I'm Leandra Hazlett.
And in episode 3, we're going to talk about the case of circumstantial evidence. If you missed episode 1 and episode 2, I highly recommend going back and checking those out. Episode 1 is called Someone Call 911, where we unpack the Casey Anthony murder trial, starting with the infamous 911 calls. And then episode 2, there's a dead body in the damn car. Those are not my words. Those are the words that the grandmother said when she smelled Casey Anthony's car. And so that all leads into this, I think the theme of this entire podcast season, which is unreasonable doubt, the Casey Anthony murder trial. And so I think it cuts right to the heart of why we're even doing this podcast, a series, which is this the Casey Anthony murder trial? Is it the crown jewel of our legal system, or is it a chink in the armor? So, Leandra, you are our prosecutor. You are our expert when it comes to how these cases unfold and how these cases come to be. What are your thoughts as a prosecutor at this point of the Casey Anthony story?
So at this point in time, Joel, I think she did it. I think I'm going to be able to prove it beyond a reasonable doubt. I'm ready. I'm gearing up for a trial. I'm ready to go. I have my experts witnessed, subpoenaed. I've got the list of, my witnesses, and I'm ready to rock and roll. And I'm pretty confident that I can get a conviction at this point.
Now, you say that, and I agree with you 100%, as I am reading this, learning about this case, and I was not a Casey Anthony junkie like you were, or you are, because I know you really dug into this. You got Casey Anthony posters up there in your room. I understand that.
Right.
But, she's as guilty as sin. I mean, when I'm going through this story, what mother doesn't know where her kid is for 31 days? I mean, she is so irresponsible, what she is doing. But am I seeing things only through the prosecutor's rose-colored glasses? Because here's where I'm going with this. We know at the end of the day, she's a free woman. She is out there walking. I could go over there in Orlando and bump into her at Cold Stone Creamery. Great place to get ice cream. I highly recommend it if you're ever in the Orlando area. But so is this the crown jewel of our legal system? Because we know we both agree she looks guilty. If guilty had a stench to it, she's reeking, right?
Absolutely.
But she's walking free. So is this the crown jewel of what our legal system is supposed to be? Or is this a chink in the armor? So I know we're not to the end yet. Any thoughts as we are about approaching the halfway mark?
I mean, I've said it once and I'll say it again. This is what our system's designed to do. It's 12 people off the street and a jury of your peers, and it's designed in a way that they don't get it wrong. So you can be legally innocent and factually guilty. So in other words, you could be guilty in real life, like fact you did it, but in a courtroom legally be found not guilty, and vice versa. You can be legally guilty and factually innocent, which happens all the time as well. So our system's designed for the jury to make that final decision, and they don't get it wrong. Even though as a prosecutor, I know they get it wrong. They get it wrong all the time. But that's what it's designed to do. So
my dad, who was not a lawyer, he would always tell me, Joel, no, it's not you are guilty or it's not that you are innocent until proven guilty, is you are presumed innocent until proven otherwise. And so you're guilty if you did it. I mean, if you did the deed, you're as guilty as sin, right? When you go to meet your maker, you better account for what you just did, because you did it. And so there's a presumption of innocence. But here, she has guilt written all over her face, all over her actions.
Her actions are so bizarre. I mean, she spent the month that Kaylee was missing partying, getting a tattoo, Bella Vita or something like that. It's like Latin or Italian for "It's a Beautiful Life." I mean, what do you mean it's a beautiful life? Your 3-year-old's missing. But I don't know. So
So she's
Yeah, she's
22.
guilty.
Right, right. She's as guilty as sin, but yet she is going to walk free at the end of the day. And so this series is going to focus on this issue of, is this the Casey Anthony murder trial? Is it the crown jewel of our legal system? In other words, that's how our system is designed to work. Unless the prosecution can prove their case beyond a reasonable doubt. That's why we got the title Unreasonable Doubt, the Casey Anthony murder trial. Unless the prosecution can prove their case beyond that standard, the person should walk free. Is this what our founders had in mind, that someone like Casey Anthony should be able to walk free even though she has this much stink around her actions? Or is
I
this a chink in the armor?
Yeah, I don't know if the founding fathers had the forefront to think that a case like this, you know. I would like to think that that's what, I don't know. The intention is good. The intention's there. It's to prevent the government from coming in and throwing someone away for the rest of their life without due process. I mean, it's good in theory, but I think that like this case illustrates perfectly. There's holes in the system, there's cracks, and occasionally one gets away.
I'm reserving judgment here because part of me is the defense lawyer, right? I'm a constitutional lawyer. That's
Sure.
where what an expert, I wouldn't say expertise in, but that would be making up a word on the spot. But I'm an expert theoretically when it comes to constitutional law, and I care about the defendant's rights. And sometimes I find myself rooting for the bad guy. I don't know why I do it. It's like, no, prosecutors, you didn't prove your case. You didn't prove your case. This person should walk free. But then I'm addressed
Yeah.
with the reality of, if the person did it, like here, if Casey Anthony did it, I'll even go with the point of, maybe we shouldn't, beyond a reasonable doubt. Okay, but 51%, I don't want that to be the standard, but maybe somewhere between 51% and beyond a reasonable doubt. So I want to hear your thoughts as a prosecutor as you are thinking about preparing your case. And I do want to go into, at some point in time today, what a prosecutor is actually doing as far as what motions are you preparing? Are you thinking about? What are you thinking about when it comes to voir dire? But I want to go over the timeline here of the Casey Anthony
Sure.
murder trial and hear from a prosecutor what is going through your mind. So we already kind of went over, but I'm going to review just a bit here, some of the timeline. We got June 16th, 2008 is when Casey Anthony left her parents' home in Orlando, Florida, and took off with her 2-year-old Kaylee Anthony. And she was gone for about 31 days or so till July 15th when that's when the 911 calls, and go see episode 1 for what took place there. All right, July 16th. So the very next day is when Casey Anthony was arrested. She was arrested and charged with child neglect, providing false statements to law enforcement, and obstruction of criminal investigation. So what is not here in this arrest on July 16th is anything dealing with murder. And so as a prosecutor, are you making that call? Did you make that decision? Why was murder not put in there on July 16th?
Sure. So at this point in time, no one knows that Kaylee, and there's no evidence at this point to suggest that Kaylee's actually deceased. We only have probable cause at this point in time to charge her with what she's been charged with. So had there been evidence, more significant evidence at that point in time to point in the direction of, we're not dealing with a kidnapped or a missing child, but instead we're dealing with a deceased child,
Right.
at that point in time,
Well, I want to kick
we
back just a little bit because I think there is enough information here. I think it is more probable than not that Kaylee is dead at this point in time, because we do know, if we just jump ahead to when the murder trial is actually going to come down. Are the murder charges? I think the murder trial is going to actually be brought here on October 14th. So we're looking at October 14th is when the murder charges are going to be brought, but we're going to start with July 16th. So that's about what, August, September, October, 3 months later. What did we learn during those 3 months? I'm going to suggest not a lot. So before we get there, is there a reason not to jump the gun? So in other words, even though it's more probable than not at this point in time that Kaylee has been something, she's been killed, is it not prosecutorial prudence to just wait and just learn a little bit more? Why be in a rush to bring murder charges when you don't need to?
Yeah, so I think if they thought at this time they had a sufficient evidence to charge her with murder, they happily would have. I think at this time, they're probably thinking maybe that's the rate it's going, but you're right. So waiting it out and making sure that your case is really solid before you, and by really solid, I mean not at the point of being able to prove it at a trial, but you have sufficient evidence to really hold on to the fact that, or ground to stand on, if you will,
Okay.
that
So,
Casey has killed. But it's a choice. It's discretionary because, again, like we talked about in the prior episode, speedy trial starts clock ticking, clock it. The clock starts as soon as you
okay.
file that information. So, her right to speedy trial really puts things into perspective. If you're still trying to investigate 3, 4 months in to charging it when you should have just waited to make sure you had that evidence to begin with.
Okay, so what's going through my mind is if the standard is more probable than not, I think on July 15th is more, or July 16th is more probable than not that Kaylee was dead. But let's say that on July 18th, Kaylee shows up. Okay, oops. Apparently we were wrong. And so I guess
Right.
would that be mud in the face of the prosecution? So there really is no benefit to rushing judgment. I mean, they already have her in jail. So it's not like she's out there just
Right.
roaming the streets as a free person. She's already in jail. So I guess is it to their benefit to wait until they have more information?
Yeah, I don't know. At the point of the time she's arrested, they don't know about the insect activity. They don't know about the internet searches. They don't know about
Ah,
um,
good point. Let's get to
the body, the blanket, the duct tape. They don't know those things. So I
okay.
think at this point in time, I think it would. I don't know that a judge would find probable cause or that early on that Kaylee had died.
Okay, I got you. I got you. Even though if I were gonna put odds at Caesar's Palace, if they were gonna put a betting line at this point in time, I am thinking I want better than 1-to-1 odds because I'm pretty sure it's more likely than not she is dead at this point in time. All right, let's go on. July 22nd. There's a bond hearing. Casey is declared a person of interest. Uh, Casey is declared a person of interest in Kaylee's disappearance. The bond is set at $500,000. And there's evidence that was presented that includes a cadaver dog's detection of decomposition in the car and the backyard. So now we got July 22nd. We got a cadaver dog saying, yeah, there is decomposition, human decomposition in the car and the backyard of the of Casey Anthony's house, parents' house. Why not murder charges on July 22nd? And why is it the bond
Sure.
hearing at $500,000? As a prosecutor, how are you processing this?
So let's start with the decomp. I think that's still that's a tally for the home team or the prosecutors at that point. But again, that is just evidence that there was a body. That doesn't necessarily mean Casey's the one who did it. So now it's a matter of who had access to the trial during that time, who had access to the vehicle. Okay, well, we know it was Casey for sure. Who else? That kind of thing. Those would be the questions playing devil's advocate that I'd be playing in my head before I bring charges. So again, I think that points to Kaylee's deceased spot is deceased, but her body was somewhere in the vehicle
Okay.
at some point.
So,
And then for bond, a bond is a number, a cash amount set by a judge to ensure you will continue to show up for your hearings, and can put conditions on you that you have to follow while you're waiting, like pretrial. So here in Nebraska, we have pretrial services, which is like probation on the front end. If a judge orders it, you might have to wear a GPS monitor. You're going to have to do alcohol testing and drug testing. You're going to have to check in with your pretrial officer, those kinds of things. So it basically just ensures that you're going to keep showing up. And the higher the crime and the more egregious the facts, and more egregious your history, the higher the bond is likely to be.
now, Leander, as we go through this process, I am going to ask you questions that I am wondering myself. And the reason why I'm doing this is I know our listeners are probably having the same questions pop up in their mind. So if you don't know the answer now, I'm at least putting you on notice that in a future podcast, you might
Sure.
have the answer. And so here's my question about this, what you just said. Okay, the bond was set at $500,000, and we already discussed in episode 2 what that means, and that is some bondsman is going to have to forward that money, and so there's going to be a fee associated with that. Usually, it's about 10%. that the person is going to have to, whoever's going to have to pay the bonding company 10%. So here, $50,000 for a $500,000 bond. Okay, here's my question. What happens 2 weeks later if the court says we want to revoke the bond, which I know they have reason, they can do that, and I've seen it done in many situations. Does the person get their 10% back, or is that money that they already spent that is now lost in the wind? Did you have any idea the answer to that question?
Yeah, so the answer is it depends.
Are you a
Our
lawyer?
favorite answer.
You are a good lawyer.
Yes. It depends, and it depends on whether or not the court forfeits the prior bond. So if you're out on bond, right, and the state or the government decides they want to file a motion for bond review, they can request that the judge forfeit your prior bond, depending on how egregiously you violated your bond conditions, right? And ask that that bond be forfeited and increased. So any money you put down initially, and then um, whatever's ordered in the future, it's a loss. You started out at zero,
Right.
right? If you file bond review, alternatively, a judge could say, we'll just leave the money. So say it's 10,000, 10%, the first one, and you've already
All
put
right.
$1,000 down. Then you only have to post the additional amount.
Okay.
You don't
So
lose that thousand
So
dollars.
I'm just going to put you on fair warning here that I'm going to come back to this quite a bit because I don't know why I'm so fascinated by bonds and how much money you pay. Maybe I see a potential business opportunity there. I don't know. But I'm going to come back to that several times because there's a lot of bonds that are put here and then bonds that are revoked and then back on bond and then revoked. And so I'm just wondering how that whole process works. All right, let's keep going here with the timeline. This next one fascinates me because we don't live life in reverse. I often wish that we could because I would like to not do the mistakes or maybe do the mistakes with more grandeur. I don't know. But on August 11th through 13th, meter reader Roy Kronk calls the police 3 times about a suspicious object, which was a bag in a wooded area near the Anthony home. But the initial searches by the deputies found nothing. I heard some reports about this where the police really didn't look that hard, didn't take poor meter reader Roy that seriously. Any thoughts on this? The point here being that a bag was discovered by the Casey Anthony home. We're going to come back to that here a couple months later. All right, August 20th, 2008, California bounty hunter Leonard Padilla posts Casey's bond as she is released from jail. All right, she's a free person now. Any thoughts?
No, not at this point.
So
I
she
mean,
is a murderer.
that's the process.
She's a murderer. Why was
She's
she?
not charged with murder yet,
Oh,
right?
no, she's not charged with murder. You're right. She has not been charged with murder. She's been charged with child neglect. So why
Right.
the $500,000 bond for someone charged with child neglect? That's an interesting thought. So at some level, I'm going to say the court thought she was a murderer, or else why put a $500,000 bond? Okay, does that make sense? You are neglecting your child, so go to jail, and your bond is a $500,000. That's how egregious your acts are in neglecting your child. Well, then how are you caring for your child? I mean, it's got to be the court thought she was a murderer. That's why they threw her butt in jail, but whatever.
Yeah, I'm not sure. I'm not sure. And bonds can be so It's so discretionary on the court. So one judge, one on Monday, could come in and set a $3 million bonds for each case, and then the next day a different judge comes in and it's a 50,000, 10%.
There
It's
you
just
go.
depends on the judge.
Okay, good inside information there. August 30th, Casey's bond is revoked. Oh, by the way, so the first bond by Leonard Padilla was posted because he was a bounty hunter. He had national influence. He wanted Casey Anthony to be released so he could go find missing Kaylee. 10 days later, that bond is revoked because of she was arrested for allegedly stealing and cashing a check from a friend. I don't know why you would revoke a $500,000 bond. I think, correct me if I'm wrong, wasn't this stealing of someone else's check done before she ever was put in prison the first time?
I actually can't speak to that. I'm not familiar.
Yeah. All right.
Timeline wise, I know that she was in trouble for doing that, but
Yes.
I don't know
So
if she cashed it when she cashed
So
it.
what happened was during the 31 days. In fact, I think this is like right before the 31 days was up. One of her friends was going to the out of the country, and so she went and got her checkbook and started forging checks. I believe that's what this is in reference to. So this happened before she was ever arrested the first time. But this goes to your point that it just if new things come to light, the court might say, well, we did not know this the first time around. Now this $500,000 bond should be raised because you wrote a bad check. I'm going to go out on a limb here, and you don't have to respond if you don't want to. There's never been a $500,000 bond placed against a person for writing a bad check. Is that even a thing? I guess maybe it is.
You would not believe the bonds we see where
Okay.
I'm at.
All right. Go
I
on.
mean, it is not unusual to have multi-million dollar bonds depending on, or no bond depending on the crime.
I guess that makes sense if the person is likely to flee. Here you got someone with no money, but she has shown a propensity to flee. I guess she was gone for 31 days, so I guess all that would come into play here. All right, let's go to October 14th. This is a big date here. Casey is indicted by a grand jury on charges of first-degree murder, aggravated child abuse, aggravated manslaughter of a child, and 4 counts of providing false information to law enforcement. She is held without bond. And so now we have no body. It's been 3 months. Nobody has shown up. I already told you I would have played the Vegas odds that Kaylee was dead as of July 16th, because what mother does that? Something had to have been horribly off. But now 3 months later, everyone is saying, yes, the baby is dead. And so we're going to bring manslaughter charges against Casey. What's going through the prosecutor's mind here? October 14th.
Okay, as a prosecutor, I'm still excited. I still think I have a strong case. I'm not really that worried. I know that the other evidence that we haven't talked about has been coming up, all circumstantial, but still it's pretty strong in my opinion. However, I want to preface, or I guess like put a little chilling effect on our excitement, because like I said in the last episode, you can indict a PB&J sandwich. You
Right,
could
right.
indict. It's literally so easy via grand jury, because there's no rules, and as far as what comes in, the state gets to put everything forward, all of the evidence they have. The defense doesn't have a right to cross-examine the witnesses, so you're basically, the state gets to throw everything at the wall, no questions asked, to see if we're going to bring charges via the grand jury system. So while she was indicted on serious crime, serious charges, you can indict. The level for indictment is so low
Right.
that I don't want anyone to get too excited. Like, oh, they were indicted. Anyone could get indicted.
And,
So
and the point here is there's just simply no one on the other side. The defense is not there. The defense attorney is not there to put their spin on it. Just the prosecutor putting the prosecutor's spin on it. And so it is pretty easy to get an indictment if you're even close in the realm of the area of an indictable action. All right.
yeah.
So this is October 14th. Now, why aggravated manslaughter and not first-degree murder?
That's interesting. So I, again, can't speak exactly to what the evidence that was presented at this time. I think at that point they probably believe, if I had to guess, okay, I think at that time they had the inkling that Kaylee's dead at this point and Casey is responsible. So a lower level homicide charge is going to be that manslaughter charge. In order to bring charges of first degree murder, and I don't know what the rules are in Florida, but usually it has something to do with proving premeditation or
Right.
deliberation.
So let's talk about that here.
And
What do they not have? I mean, they know the baby's dead because it's been way too long and Kaylee hasn't shown up. But they really don't. You have a decomposition. You have a dead body in the backyard. All those things could be consistent with an accidental death.
right. And so exactly. And again, in order to prove that first degree, that's the highest level, or capital murder, I guess would be the highest level. And again, statutes are different in each jurisdiction, but that highest level of murder, that first degree, you're going to have to show some type of premeditation or deliberation in order to get there. And that's a jump, because at this point, we don't know how she died. We just think she's dead. It's likely she's dead. It's likely that Casey had something to do with it, but it could have been reckless. She could have drugged her, which was a case theory, so she could party. She could have drowned in the swimming pool, which was a theory.
Right.
And so we're not at that high level yet.
So
We don't have enough evidence.
So tell me what your thoughts are on this. I think the fact they went with aggravated manslaughter as of October 14th proves the prosecution was very worried about this issue because they could not prove intent. What they could prove was extreme recklessness. You got a 22-year-old out there partying around, gone for 31 days, making up these crazy stories. If you want to talk about immaturity, I mean, this is your poster child, right? For immature
Right.
actions of a 22-year-old that almost is consistent with manslaughter and contra to first degree murder because she's just highly irresponsible. So if there was an accidental death, it seems likely that maybe she tried to cover it up in some kind of odd, stupid, immature way, and that's what took place. I guess I would think from a prosecutor, this highlights they were concerned with proving premeditation.
I think at this point in time, yes. I think that they were very aware that they didn't have enough evidence to get over that bump and that, well, how would you call it? Get over that
Hurdle.
hurdle.
Right.
Hurdle. Yeah.
Okay, 10 days later, October 24th, forensic reports are released, this is what you're waiting for, revealing a hair strand in Casey's car trunk, microscopically similar to Kaylee's, with characteristics of decomposition. Air samples from the trunk show chemical compounds consistent with human decomposition and high levels of chloroform. So with these reports 10 days later, does this change your mind as to premeditation? Or is this in line with potentially just being manslaughter?
I still think at this point in time, that's great evidence. It's great evidence that points that Kaylee is deceased. But I think at this point in time, we're still not over the hurdle because it could have been reckless. It could have been unintentional. She could have been drugging her, which was a case theory at one point. So she could go out and party and act like a normal 22-year-old and had Kaylee just asleep, and
Did
then
you say
she
act like a
overdosed.
normal 22-year-old or abnormal 22-year-old? Because I'm not quite sure I
No,
heard
sorry,
you correctly.
a normal 22-year-old, like out partying, having fun, living it up.
It's been a while since I've
She
been
was,
22. I'm just going to leave it at that.
yeah.
All right. October 28th. Casey is arraigned and pleads not guilty to the charges. So, are you shocked at this not guilty plea?
No, not at all. No one comes in at arraignment and says, "Hey, yeah, you got me. Yeah, I did it." No one does that.
All right.
Arraignment is your first court appearance. You're before the judge. It's a formal reading of your charges, so you're put on notice formally, and then you enter your
Not guilty plea?
what yeah, no, yeah, it's not a plea though. You enter your position, and I can't think, I'm drawing a blank. We're gonna have to cut all that out.
Yeah,
You enter
that's an easy
your
cut. It's an easy cut.
Okay, cool. So you're formally arraigned, you're formally read. You go before the judge for the first time, your first appearance. You're formally read your charges at that point in time. So your formal notice for due process purposes, and then you just enter what you want to plead. And if that's guilty, it's guilty, which never almost certainly never happens, or not guilty. And so you enter that. Not guilty is put in on your behalf, and then you get your next hearing date.
We are going to do an entire episode one of these days on the not guilty plea because I do a whole comedic bit on this because I am convinced this is out and out lying. I believe there's a Latin phrase, "Mendicant de asinus," lying out the asinus. Because why even ask someone? I mean, every time there is a guilty conviction, it also should be perjury charges to boot. Why do we ask?
Because you're lying to the court.
Yeah.
Yeah.
You're as guilty
crazy.
as sin. You're wearing the victim's Rolex watch in court. Dude, you bragged about it on Facebook. Clearly you did it, but they always plead not guilty. I don't understand that. That is lying. But
I had hang on one second. I had a robbery case where the guy came in for sentencing and he robbed a eyeglass store, and he came in luxury brands. He came into sentencing wearing one of the stolen like Louis Vuitton tinted glasses. So obviously at that point he had changed his not guilty plea to a no contest plea, but just food for thought. That does
It
happen.
does
Stuff like that
happen.
does happen.
Yeah, I don't get it. So yeah, shock upon all shocks. Pleads not guilty. December 11th. So now we're talking about approximately 6 weeks later. Skeletal remains of a young girl are found, later confirmed to be Kaylee. Of course, you know that, or why else would I be mentioning that here? They are discovered by a Roy Kronk. That name sounds familiar. We mentioned him earlier. In a wooded area less than a half mile from the Anthony home. The remains are in a laundry bag with a blanket. Duct tape is found around the skull's nose, mouth, and jaw area. A heart-shaped sticker outlined is noted on the duct tape by an FBI examiner, though no fingerprints are found. All right, does this change your thought process as a prosecutor? What are you doing with this information?
So at this point in time, and I want to expand a little bit on the evidence. We know a few things at this point in time. We know that the duct tape well, eventually we will learn that the duct tape is consistent with the brand and make of some duct tape that was found in the Kaylee Anthony household, the
Okay.
Anthony household. We know that the laundry basket that Kaylee was found in was sold in a pair of two from Target. There was a Target brand laundry basket that came in a pair, and one was located in the Anthony home. The other was found with Kaylee's body.
Okay.
Okay. And then we also know that so the duct tape, the laundry bag, the blanket, the Winnie the Pooh blanket matches that Kaylee was found with, matches the bed set, the bedding, and her nursery theme in the Anthony household. So at this point in time, we now have significant connection between the remains and items found in the Anthony household.
So as a
So this
prosecutor, you feel really solid that now you are tying in this skeletal remains. By the way, was it later conclusively proven through DNA or dental records that this was Kaylee?
It was determined
Okay.
later that it was
All
Kaylee,
right. So
yeah, because she was past the point of being able to recognize her.
okay, but from your perspective, you as a prosecutor, you are now tying in the body with the car. And so this body was at one point in time in the car. Is that the significance here between the all these connections?
The connections to me is that it connects it to the Anthony household. It's not some mystery person. It's an
Right.
inside job, if you will. It's not Zanny the nanny. It's not anyone else that Casey, sorry, um, is going to try to blame it on. It's someone within the Anthony household
Okay, so
is responsible for this.
you feel good with this proof that if you go in front of a jury will believe beyond a reasonable doubt that Kaylee was in the back of that car, was probably transported, and then dumped off at that scene. You don't do that with that's obviously not normal actions, and so that's indicative of a murder. But I guess it doesn't prove that you murdered the person. It just proves that you disposed of the body. I guess, are you making
Right.
that leap that you then did the murder? Or are you worried that we also got to prove we did the murder? Or and again, the
So
juries even make that distinction?
yeah, so depending on at this point, can you rephrase the last part of your question
Did
about the
jurors,
jury? What?
yeah, did jurors even make that distinction? So if you were going to convince a jury of I disposed of this body, would the juror
Sure.
then just say, well, then you did it? Because who else was going to dispose of the body? You're the mother. I
Right.
mean, it's not like you're just some kind of hired hitman with a mafia group. I mean, you're the mother
Right.
disposing of your
Right.
child. They'll just leap right to you committed the murder.
So I think it depends on the jury. Obviously, I think if I'm alleging, you you dispose of this body improperly and that's its own crime, then you are almost certainly responsible for the homicide as well, or the murder as well. But
But
I think there has to be other evidence to support that you also murdered
because
the child. And so at this point in time, as a prosecutor, I'm not worried about who done it, if you will. I'm
right,
worried more about the intent because again, for that first degree murder charge, I'm going to have to show beyond a reasonable doubt that her intention was to cause the death, and I thought about it that she thought about it ahead of time,
right.
even if that ahead of time was margin of a second, a moment in time, a split second in time, had the intent to kill Casey or Kaylee, sorry, versus hey, this was an accident. At this point in time, as a prosecutor, my concern would be proving intent.
Because at this point, I mean, theoretically, there is a difference. I'm not theoretically, I mean, technically, under the law, there is a difference between disposing of a body and taking the life of a human being. So, in
Right.
other words, it could have been that the body, that Kaylee died accidentally, and maybe it was done in such a way that Casey was worried about what that might show about her as a mother. Maybe even the mother was on drugs. I don't know, but at some point, just because you disposed of the body, that's a different crime than actually killing a person. Though I do wonder if a jury will see that distinction, but technically it is different.
Right.
Okay, so let's dig into that as well, because we also are going to have the computer search. So explain a little bit about how what showed up on the computer search, how that plays into a first degree murder charge.
So there was a few suspicious searches on the family computer, and we have to remember this is back in like '08. So no one's, not everybody has individual laptops. A lot of families had home computers that were in a common space where they're, and this was no different for the Anthonys. The family computer had different users for each member of the family. So Casey had her own login. Her mom and dad had their own login, but it was one communal
Okay.
computer. And so the searches that they found on the family computer were for self-defense, chloroform. I want to say how to make chloroform. Um, it was just chloroform and self-defense.
Okay.
So I think that goes, or it could go to premeditation for that first degree, that intent requirement for the first degree murder charge, because that shows a presence of mind ahead of the crime. Somebody was taking the opportunity to search, to sit down and research how to make chloroform or how it operates or how it works, those types of things, and shows in a timeline that there was some forefront thinking prior to the crime.
Okay, so as a prosecutor, you get this information. You have a computer search that was done regarding chloroform, and and
Right.
and what else did you say about
There
well,
was a search for self-defense, which is interesting because it wouldn't, that's not really necessarily applicable here,
so
but
in other words, you're thinking about the death of your child. That thought process is on your mind. I can guarantee you, you go search my computers as much as you want. You won't find any searches even close to that, nor would you ever find that search on any reasonable, normal person. So the fact that a jury is learning that someone in that household was searching that information, and then the Kaylee is found dead later on, those have to be connected. That's the kind of coincidence that is unreasonable. If we're trying to find what is unreasonable doubt, that would be unreasonable doubt, because
right.
those two will be connected.
And that's a perfect example of asking the jury to make the jump between uh obvious the circumstantial evidence layer where we don't see these things happen direct. There's no direct evidence of any of this stuff happening, but we're asking them to take the leap and make the connection between the family computer search of chloroform. Kaylee is deceased and there's chloroform present in the vehicle. Draw your conclusions,
All right.
or make that leap,
So I
and
want
tie that
I
together.
want to press down a little bit on this. I'm trying to think as a prosecutor would think, which I'm going to take a shower after this, but whatever. And sorry about that. The in this situation, what am I thinking about? I'm thinking about what would a defense attorney say? A defense attorney would say, who else has access to that
Right.
computer? So who else would have
And that
access to this computer?
so Kaylee, or sorry, Cindy, Casey, and George
Okay.
all have access to this
So let's
computer.
talk about
And
Cindy first.
so Cindy, yeah, so Cindy actually testified on cross, I think, that she was the one who made the searches on the family computer, taking responsibility, which I think is a weird thing to do. But the timeline of when those searches were done did not line up with when
Okay.
Cindy was at home. She was at work
There you
during these
go.
searches. So super bizarre to admit to something if you didn't truly do that. I can't speak of if she was lying, why she would lie about something like that.
I
But
have found that yeah, clients will lie all the time, and to defend someone, to protect someone they love. Here, Cindy is maybe trying to protect her daughter in this situation. Maybe the shock of losing her granddaughter has rubbed off, and now she's trying to also save her daughter. I don't know. She's not going to win Parent of the Year
yeah.
award, right? We got that. Why would she lie? So she tried to claim it. Clearly, that's not going to
Yeah.
work. What about the dad? He had access to it, did he?
Yeah, I
I mean,
almost
the
certainly.
grandfather.
But yeah, George, but she didn't, or he didn't. There's no, as far as I know, he didn't testify to or take credit for making those
But
searches.
did he have access? Could
And
the defense attorney say he's the one who did that search?
well, and that was one of the issues as far as poking holes in the state's case. They couldn't prove definitively that Casey was the one who made those searches because other people in the household had access to the computer.
Okay.
So it's possible.
So right here, as a prosecutor, you're looking over this evidence. You're saying, "Am I going to take this to trial? I got to prove my case beyond, reasonable doubt." And here you're saying there's two people that have access to it reasonably. You got Casey and you got George. What's going through your mind as to why the jury will take your version of the events and believe it was Casey?
So So I think when you look at the evidence as a whole, so I'm not asking, I would never submit to a jury to convict somebody beyond a reasonable doubt on that evidence alone. But when you look at the bigger picture, she's out for 31 days, partying it up, getting
Okay.
tattoos, acting not like a mourning mother. She lies, like doesn't just kind of lie, like she lies
Right, right.
about
She'll be in the
the
Hall of Fame for
last
liars, to be
whereabouts.
sure.
Right. Like it's insane. Um, then the physical evidence in the car, the duct tape being from the Anthony home, the laundry basket being from the Anthony home, the blanket being from the Anthony home, the heart sticker. I mean, whoever disposed of this little girl's body, somewhere in them loved her. Maybe. And I say that because I don't know. Loved her in enough to put a heart sticker on her. I don't know. And then we have the computer searches. And now I'm asking you to make the connection and make that leap that it was Casey because all the other evidence points in that direction as well. So is it likely that George had access to the computer? Yes. Is it possible that he made those searches himself? Yes. Does that make sense when in light of all the other evidence? No, it does not.
And also, if you're going to look at the 30,000 foot level, which is why would George even do that? I mean, that doesn't make sense.
Right.
What theory has George doing this? Now, I know that the defense will come up with a theory, so we'll analyze that later. But at this point in time, you're looking at the actions of Casey, who could care less that where her daughter is, right? She's 31 days out there partying, and we know the timeline what she did. And then you see the actions of George, and yeah, you make the call as a juror. Which story do you think is plausible? Which jury do you think is not? Again, which one is reasonable doubt? And which one is unreasonable doubt? All right, let's go on with our timeline. We got December 20th. If I just read my notes a little bit down, the remains are positively identified as Kaylee's via DNA. And so they have a homicide of undetermined means. So January 23rd now, George Anthony is taken into custody after a suicide attempt at a Daytona Beach hotel where he is found with a 5-page suicide note. Leander, I did not see that coming.
I
Tell me what
didn't
this is
either.
about.
And I remember when this happened, and again, we talked about this in the first episode. The family dynamic in this case is so bizarre. And I don't, sometimes suicides and flight and all the other things can point to some type of guilt or culpability, or you can make that argument. I don't know that we get there in this case. I think that he was a broken man at this point. I mean, eh, his family is at the heart of a nationwide, like not witch hunt, but like his daughter's being fried at the stake, rightfully so, in my opinion. But and he's lost his grandbaby, and he's being accused, or he knows he's about to be accused of all kinds of heinous things on the behalf of Casey. Casey makes case theory that George was sexually abusing. I said case theory, and Siri activated on my computer. Um, Made arguments that George was sexually abusive to Casey her entire life. No one knew who the dad of Kaylee really was. They made argument that George was potentially the father and that he killed Casey or Kaylee to hide that fact from coming out, or to hide any proof of his physical and sexual abuse. So I think at this point in time, he's just at a loss and doesn't know how to cope, and made an unfortunate decision to try to kill himself.
Now, I might butcher how I'm going to phrase this next question. I'm going to try to do my best. But was this suicide attempt legitimate suicide attempt, or do you think it was a defense strategy and stunt? I mean, you know what I'm saying? Because this obviously is going to play
No.
perfectly into the defense's theory of the case. Was this
Right.
done to kind of insert reasonable doubt? Or do you think this was
I
a
don't
legitimate grieving person who thought the suicide was the only way out?
I genuinely think he tried to kill himself, and I genuinely think that he did it because he couldn't take anymore. But interesting point that he played right into the theory. And I was actually kind of thinking, had he died, had he actually been successful, then the defense would have had a heyday, even more than they already did, about his abuse and hiding, and this alternate theory that he was responsible and he's so guilty that he killed himself, before
Right.
trial. And so you can't acquit, or you have to acquit Casey because clearly George did it. So that's really interesting, but I don't think it was done purpose as a diversion or on purpose to help Casey, because both of her parents are like not supportive of her now, especially not George, especially not after
Right.
the that stunt came out. Casey's stunt about George being abusive came out.
Okay. April 13th of 2009, prosecutors announced they will seek the death penalty, citing aggravating circumstances. Now, I have a friend of mine who was a former prosecutor in Illinois. He told me that one time he had to seek, or he chose to seek the death penalty against someone, for a crime there in Illinois. I can't imagine having the responsibility of deciding I'm going to pursue someone's death. Again, to me, that's not something I would ever want to do. That's why I'm not a prosecutor. Speak to this a little bit here. The strategic decision of the prosecutors to seek the death penalty in a case that probably has a lot of holes in it. Again, I'm not sure they have a slam dunk case when it comes to first degree murder, because it's going to be really hard for them to prove intent. Manslaughter, I think, is an easy case here, but actual intent as compared to you just messed up as a young person, I don't know. What are your
Yeah.
thoughts on the decision to seek the death penalty? Did they go for too much?
No, so the death penalty is in it. We can do an entire series one of these days on the death penalty, and we can unpack all the different theories of punishment, because it's one of my favorite things to talk about, but it will take like a week to break everything down. Because it's so loaded, okay? This is not the case that I necessarily morally or ethically would pursue the death penalty, just because again, it's so circumstantial. However, I don't blame the prosecution in this case for filing it that way, even though I believe it largely to be political. Most prosecutors are elected and or appointed positions. Most of the ones that I am familiar with, most states that I'm familiar with, the prosecutors are elected, and the death penalty can be used and often is used as a political tactic to show that you're tough on crime. And in a case where there is a missing and then murdered little girl, it would be egregious to not file
I get that.
charges with the death penalty.
I get that. But what I'm concerned with here, from just analyzing how this case is going to play out, is that I wonder if jurors apply a different standard when it comes to death penalty cases. So, in other words, whatever beyond a reasonable doubt means to a jury, if it means X in a normal first degree, you're going to spend the rest of your life in jail kind of case, then in a capital murder case, it means X plus 10. Right, your case has to be that much stronger now for me to get to the point where I'm going to allow for someone else to die.
And I see what you're saying. I don't know. I'm not 100% certain that when a jury or when a case is charged with the death penalty versus just a regular first degree murder charge, that the jury is put on notice that the death penalty is a possibility, because death penalty is a separate phase of the criminal process, where once there's a conviction, the judges or the panel, at least in Nebraska, it's a 3-judge panel that then decides if there's enough aggravators there to sentence the person to death. So I don't know that when you pick a jury and the jury says, they don't know anything about this case and they've not read about it, they've not heard about it, they're completely neutral, unbiased, fair, and impartial, that they know anything about whether or not the state's pursuing the death penalty. And regardless, they're instructed, not that everybody follows instructions, but they are instructed that it is not their job to determine what happens to the defendant. Only their job is only to be the finder of fact if that person is guilty or not. They need to reach a verdict, and then the judge is the person responsible, or the court is responsible for what happens to them as a consequence.
Okay, so I get what you're saying, that every jurisdiction is different. That's a good point to point out. But then I want to push in a little bit to what you said is the rule in Nebraska. So in Nebraska, you're saying it's the judge, or it's the 3-judge panel that will decide if the death penalty is appropriate. But does a prosecutor have to pursue it before this 3-judge panel even makes that determination?
Yeah. So if the state has to file it as a death penalty case when they file the information. So if they're seeking the death penalty for the jump, there's no secrets. Everybody knows that this is a death penalty case, right? If it goes through the normal process. If there's a trial, there's a trial. Once there's a verdict, at that point, when it comes up to sentencing, it goes before the panel, and they make sure there's enough aggravators there to actually pursue the death penalty. And if they decide there's not enough, then it's just life without parole, because that's the normal consequence for a first degree murder charge. Alternatively, if it's a first degree murder charge, not the death penalty, and they're found guilty at trial, then at sentencing, the judge is the person who the single judge that oversees the entire case is the person who sentences to life without parole.
Fascinating distinction. I wish I knew a Florida attorney that could speak to what the rule was in Florida. Oh, that's right. I am a Florida attorney, but I still don't know the answer to that question. Hey, maybe I will find out the answer to the question in Florida. All right. And so let's see what else we have here in our timeline before trial. Well, on May 9th, I have that jury selection begins in this case. And so, we've been going almost an hour now. So maybe actually this is a good launching off point to just kind of wrap up what we've discussed so far in today's podcast, because the theme of today's podcast was unreasonable doubt. And so, a case of circumstantial evidence. And the title of the series is Unreasonable Doubt. What do you think about our circumstantial case right here as you are going to trial? So what is going through the prosecutor's mind as you prepare for trial? Are you thinking, I got to have a theme to the case that I present to the jury? Are you thinking I'm going to write my closing argument first? How are you going to take all these facts that you and I just unpacked here? And I'm sure there are a couple other facts that we missed, but how are you assimilating all of this to come up with a theme and that you are going to present to the jury? Well, how are you processing this?
So there's like mixed reviews. I like themes. I try to find, if I don't force them. I've learned in my career, you don't force a theme. If it's readily available, then you use it. If it's going to assist the jury in making their decision. If it's not, if you force it, it feels clunky. It's not good, and you shouldn't do it. So in this case, I think the easy theme is the mother of the year, right? Like, and I say that sarcastically.
Right, I get you.
And I would use that. I would use every fallacy that Casey has as a parent to show her guilt. through the process. So I think her lies, her partying, her behavior speaks so much louder than any of her actions, as far as aiding the police and inhibiting the police investigation. The physical evidence again, so circumstantial, getting back to that, this case is entirely built on circumstantial evidence, and I want to reiterate that that's not a bad thing.
Right.
A lot of cases only have circumstantial evidence, and again, I'll remind everybody that juries are allowed to consider both circumstantial and direct evidence. So just because in this case we don't have any eyewitnesses saying this is what happened and I saw it, we can make reasonable conclusions, or like take the jump from, hey, chloroform was found in the vehicle and someone on the family computer searched chloroform. um, it's likely that I'm asking you to then believe that Casey's the one who searched the chloroform and then it was later found in her vehicle. Or I believe Casey had Kaylee's deceased body in her car. I don't have any direct evidence of that, but there's decomp and hair banding that points to the decomposing body of Kaylee in the vehicle. I'm asking you to make that connection and that conclusion, tie it up in a bow and find her guilty. So at this point in time, I'm not worried about my case. I believe I can prove it, but I do understand that it is
Well, I think
circumstantial.
you're going to win the case as far as saying, was there a dead body in Casey's car? Did she dispose of that body, or at least use her car? I mean, I think it's a slam dunk winner for you. But where you're weak on is saying that this is premeditation. Because I think that this easily could have been an accident that an immature person then covered up. So how are you
Right.
going to overcome that pitfall in your case? And I like your theme of this is not how a normal mother behaves. I mean, a normal mother doesn't do this, and so it does speak to murder. Would you do mock trials to see how different theories play out? Is that something that you would do in this case?
No, and I think that's so funny that you say that because we watched Suits a while back, and sometimes Suits is like spot on, and other times I'm like,
Right,
this is
right.
dramatic, like this is would never happen. We don't do mock trials necessarily, as at least where I work, but I would absolutely run it by a million different attorneys. Every criminal attorney has a different take. They bring excellent insight, things that you're prone, at least I'm prone to overlook. I have other senior attorneys in the office that'll be like, "Hey, did you think about it this way?" And I'm like, "Shoot, back to the drawing board," because I would have never taken it that way. But they've got a lot more experience, so that's priceless. So no mock trials, but I would definitely spin off different theories with other attorneys and see what sticks and what we think is the most likely based off the evidence. So
I had one case I was familiar with happened to my neck of the woods in Olathe, Kansas, where it was an odd murder and they really struggled with motive, and they ran mock trials, 20 years of mock trials, and never could score a conviction. So they did not bring charges for over 20 years. They took a weird break in the case 20 years later before they ever brought charges. And they also brought charges at the end of the day because they thought it's been 20 years. What are we waiting for? But it,
that's interesting.
yeah, they couldn't score a conviction in that particular case. They thought, why are we going to waste our one shot for nothing? Let's wait till we get a more solid case. And here, I am concerned with premeditation, and I am absolutely convinced she's a horrible mother. Like I said, she's not going to win Mother of the Year award, but that's a trap in this case. It's like, man, such a strong case. I mean, you got 10 out of 10 on all these different areas. Dead body, disposing of the dead body, you research chloroform. I mean, all this that you did, but what do we actually have that shows premeditation? Maybe they're hinging all of this on the computer search. Maybe that's their secret ace in the hole that's going to prove premeditation. But nonetheless, okay. What about motions in limine? Are there any pretrial motions as
Sure.
a prosecutor you are worried about before you head out to trial?
That's a really excellent question. And in a case like this, I would want that. I'm trying to think. I guess her partying and all that stuff that isn't really relevant or you wouldn't think would be relevant. I would want that to come in for sure as um
Right,
I'm
right.
trying to think I'm trying to think. My gears are turning. It wouldn't be motive. It wouldn't be identity. It wouldn't be intent. It wouldn't be absent a mistake.
Let me throw a couple things by you. So you mentioned partying. As a defense attorney, I would be concerned about that because I would be concerned with character evidence coming in for an improper purpose. So generally, character evidence is not allowed in a trial because you can't just say this
Right.
person's a bad dude, and so the jury is going to say, well, because they're a bad dude in other ways, I'm going to assume they're bad in this particular situation. If you're going to bring in character evidence, it has to be for some purpose, like to prove motive, to prove planning, to prove you acted in conformance with your habits, whatever. It just can't be
And
because you're a bad dude.
right, and off the top of my head right now, I can't think of what exception I would bring it in under, but that would be something that I would look into because like again, it's like motive, opportunity, absence of mistake, modus operandi or whatever.
What about
Like
this? Oh, go on.
no, I was just thinking out loud. I don't know what I would bring it in under, but that's something that I would definitely be interested in showing as relevance of her behavior speaks to that my case theme. So I
Right, right.
definitely want it coming in.
What about are you concerned with the defense pointing the finger at someone else? Are there things a prosecutor can do that can limit the defense's ability to say, this person over here is the one who actually committed the murder? I mean, can the defense just point to anyone else out there in the public and say, did you consider this person? Or are there rules that kind of hinder what the defense can do when it comes to pointing the finger at someone else?
Sure. So I don't know like exactly if there's rules that would prohibit that, but the defense is pretty open to being able to present whatever poke holes as long as it's reasonable. So it's not unreasonable for the defense to say, did anybody think about George? Did anybody think
Right.
about George Anthony? He had access to this kid, yada yada yada. I mean, as long as it's supported by some type of evidence, they're allowed to point fingers at whoever they want to point fingers at.
And this also might get cut from the final recording, but in that earlier case that I mentioned, I do know that one of the things that the defense wanted to do was say, hey, there was another crazy person in the insane asylum who's saying he committed this murder. Why didn't they look at that crazy person as being the murderer? Because he said he did it. Well, I guess you could see why the prosecution didn't want to allow, or the court did not want to allow that in, because now the jury is going to be thinking, well, someone else claimed credit for this murder. Would that unduly prejudice the jury? And so in that case, they kept that out. And I didn't know if there's a standard for when you can keep out other people as
Yeah,
being a potential suspect.
so the answer to that is if it's unfairly prejudicial, meaning it's more prejudicial than it is beneficial, and then if it would confuse the issues, confuse the jury, or there's like a list of things that would keep something from coming in, and those two being the biggest ones, the
Okay.
unfairly being unfairly prejudicial or confuse the jury, confuse issues, mislead the jury, that kind of thing.
So if someone in the insane asylum is taking credit for a murder, the defense, it doesn't get a free pass to tell the jury, hey, that person did it, and the police didn't inspect it enough. Being that person's taking credit, that might unfairly prejudice or confuse the jury. All right.
So to speak to that just briefly, very briefly, is it's going to depend at the end of the day on your judge because they're the gatekeeper of what evidence comes in and doesn't come in at trial. So had that been tried in front of, or had that issue come up in front of another court, it's not unlikely that that information could come in. So interesting.
Well, I am fascinated about our next episode. For our next episode, we are going to present to you what actually was the theme of the prosecution and what was the theme of the defense, because we know where this is headed. This is headed to a not guilty verdict. And we are both scratching our head going, how? How do you get in this fact when it is so clearly that this person did it and is guilty? How did they, at trial, get to a not guilty verdict? So I don't know if this is the crown jewel of our legal system. This is how our legal system was designed to operate, or is this a crank in the armor? But I guess we'll have to wait until our final episode to see how that question is resolved. Any final thoughts as we look forward to our next episode?
Nope, just super excited about the next one.
All right, we'll see you next episode, and go
All
out
right.
there and keep prosecuting.
Thanks. Bye.